So, these two values, on the one hand, a certain predictability from the legal order which excludes intolerable amounts of uncertainty, and secondly, a manner of treating those subject to power in ways which take account of their humanity, their existence, their voice, their arguments, their interpretations of the situation on the ground, etc. These are two elements of an opposition to arbitrary power which are distinctly legal values. That is, they are values which, if you think of law as an enterprise of governing people according to rules, it's not my definition, but it seems to me a good one, if that is what law is, then that enterprise only acts unarbitrarily to the extent that it does so in ways which are routinely knowable in advance and that enable people affected by power to have this access and influence and voice in the application of it to them. So that's, at last, I'm now going to gallop. That's at last the first of my four questions dealt with. That's why. Now what? I don't need to gallop so far because that's the most important question for me. What is the rule of law? Now, again, if you look, people have, like every hurrah term, and rule of law has become a hurrah term, like democracy, justice, equality, everybody has their own definitions. I'm looking for something which is general enough to capture the institutionalization of such values across a long swathe of countries, not so tied to what we do here or somewhere else, because there are different ways of reaching these goals. And there are ways which are similar, which don't reach these goals in some place. For example, the rule of law in Afghanistan, the importation and transportation of law to many countries where it doesn't graft well, for us to give detailed accounts of what the rule of law is. But in light of this value, and only in light of this, of some value, can you come to some sensible specification of what the rule of law is? And let me mention three which have influenced me and have been very influential. It seemed to be important. One, I mentioned Fuller's elements of law, formal elements of law, which make the law knowable when you face it. That's one strand of thinking about the rule of law. What is a specific legal value? What is a specific way of making it that power is less arbitrary than it otherwise might be? Another, and this is Jeremy Waldron, the second value I mentioned, the law, when it treats individuals, has to institutionalise capacity, voice, representation, independent tribunals, etc. Not specifics that can be done in many ways, but ways in which it can be plausibly said that a person with an interest at stake in the exercise of power has had the opportunity to bring their interest to the fore in their interpretation of the things of which they're accused to light. And there's a third version by a friend of mine, and I promised him I'd mention him, an Italian jurist, Gianluigi Palombella, and he points out a difference which nobody that I know of has mentioned apart from him, between the rule of law and its various European, similar sounding but actually different versions. We have rule of law. German has a long tradition of what they call the Rechtsstaat, the state of law. Stato diritto in Italian, same thing. L'état de droit in French. Because the state is more prominent in continental law, the state comes into the definition in the way it doesn't in common law. And that also has a lot to say about the fuller criteria. Got to be able to predictable, it's got to be general rules, and so on and so forth. Weber, in fact, said that was the only place you had those things really respected. You didn't have them in the common law countries, for reasons I won't get into. Palombella says, look, there's a difference between the rule of law as the common law understood it from about the 13th century and as it was understood in Europe until only last century, and it's this. The common law from the 13th century always had a conception that the law itself had two elements. It had an element of government. That is, if you're a governor, the law's one of your instruments of government. But it had limits which had to do with rights of citizens beyond which were in the law. beyond which even a ruler couldn't go. The 17th century in England was a fight about such things. Magna Carta was, to some extent, a fight about such things. In England, the notion that arbitrariness was contrary to the rule of law was fundamental and very long-lived. I can say more about that in question because it's a fascinating story, and Palombella, because he's an Italian Anglophile, might exaggerate it, but there is something in it that when the King of Prussia said, our law is going to be formal, clear, people are going to know it, he was just stating an operating procedure for tidy governance. It was not part of German constitutional theory in the 18th century that there was some part of the legal system which could limit what a ruler could do. That only came in the exportation to continental Europe of the 20th century of constitutions, initially on the American model, that was the first, which wrote constraints on the power of a ruler into the law. So here we have three elements. I like these as answers to the question what the rule of law is, because they're at a sufficient level of generality that you can say, I'm not saying that in Afghanistan you've got to have the common law or you've got to have a constitution. I'm just saying these are three important characteristics of a legal order which are rich cumulatively and which together constrain the possibility of exercise of arbitrary power to the extent that they are effective. To the extent that they are effective. Why do I emphasise that? Because I want to gallop on to my third question. Where? I've recently written about the rule of law in a couple of books, and I've been struck by the titles which have a certain geographic sense to them. One was called, and I don't know, this came out of nowhere. You can have books like What is the Rule of Law, How to Get the Rule of Law, The Elements of the Rule of Law. But this book, published last year, was called Relocating the Rule of Law. And in a couple of months, this lecture will come out in a book, the title of which is Getting to the Rule of Law. And my sense with these new metaphors is that these people have been shopping around, they've looked everywhere where they're supposed to find the rule of law, looked at this aspect of the legal institution, that aspect, and there's nowhere there. Because they keep looking at these countries. They've got all that. And still people are beating each other up. What a pity. But it is a pity. So my suggestion is that the three accounts I mentioned, Fuller, Waldron, Palombella, together with the vast literature on the rule of law, it's not that it's looking in the wrong place. It's not that legal institutions and their features are unimportant. Of course they're important. But the biggest difference between my view and what I take to be conventional wisdom is that most people expect to find the rule of law fundamentally in the legal institutions, the central legal institution. Why not? I mean, everyone, when Waldron says, look, Fuller's not enough, it's not enough that the laws are clear, you've also got to know how courts are dealing with people. And he says, look, I've looked around, when people want the rule of law, they're talking about the courts. They're talking about what happens to people in courts. But I don't think that in Afghanistan I don't think anywhere in the world is what happens to courts on the mind of most people most of the time when law enters their lives. And I don't think that because, and this is a kind of sociological claim, because I would want to argue that some of the fundamental sources of the rule of law, that is, of a state of affairs in which power is routinely non-arbitrary, some of the most powerful, significant sources of the rule of law are not in the legal institutions. Some of the major dangers to the rule of law are commonly not found in the legal institutions. And thirdly, some of the major goods that the rule of law delivers are not found in the legal institutions. Let me amplify those three very briefly. As to sources, you can think of the rule of law operating centrifugally and centripetally. That is, throws out messages to the world. If you've ever been in a car accident, do you behave differently if you were in the car in front or in the car in back? I'm always, what's the word? I'm always pompous if I'm in the car in front. Somebody's hit me from the rear. And I'm somewhat apologetic. Gentle, because I remember somewhere that you're not supposed to admit fault. But still, my whole demeanour is different if I was in this car or that car. Because I've got some message. I may have misconstrued it. Much of what law does for most people in every society, not just screwed up countries, in every society, is send messages. Most of what happens in the actually legal institutions, I don't know how many of you had divorces, but you will wonder, look, is it worth taking something to court? Can I cope with taking? How much is it going to cost? All these are messages which different legal institutions send out all the time. Most of us don't take things to court, partly because of these messages, partly because we're decent people, but partly because these messages are absorbed. Most of law, and a society is in a horrible fix if the law is such a hermetic, solipsistic system that it's not sending effective messages to people in their ordinary interactions with each other and with the state. But when you send messages, you're sending it out not to a vacant field. You're sending it out to a highly populated world, populated with other messages from your local organisations, from religious groups, from a whole range of other sources. And law has purchased there, significant purchase in restraining arbitrary and other power, only to the extent that its messages in some way mesh with or can triumph over the messages sent by your local tribal elder or your local religious group or your local organisation with which you deal all the time. There are some wonderful examples in the literature of what's called legal pluralism, which I could come back to in questions. I'm just asserting this at the moment. Many of the fundamental sources, the reason that the rule of law is weak in Afghanistan is not that they don't have courthouses, and it's not that they don't have trained judges, even if they don't. They could have. You could have all of that, and the problem is not there, it's out there. The Taliban is not listening. And it's not only that they're not listening, but they're talking, and what they're saying is different. It doesn't mesh with whatever law is saying. And to the extent that that is true and a powerful segment, a part of social life, it's always true that all these other things are going on. But to the extent that there is not a sync between, I'm sorry about the word, but I just got an iPhone, and there's not a sync between law and these things out there. To the extent that there isn't, the rule of law is, to that extent, baseless. It needs a great deal of social support to have any social salience. What about dangers? The Oxford philosopher Joseph Raz has a kind of tepid but influential, maybe because tepid, endorsement of the rule of law in a famous article. And he says, look, it's good for some things, but basically it's only a negative value because all it does is restrain the power of law to do arbitrary things. You've got the law, and if you've got law, then you want it to be a better sort of law, so the rule of law is only good to that extent. That seems to me myopic in two respects. First of all, states, think of Stalin, think of the Röhm purge of Hitler. States do a lot of things, exercise a lot of power without any reference to law. And the demand for the rule of law is a demand that they exercise power not only through law, but law which has these features of being knowable, etc. in advance, treating its subjects not simply as objects, but as human subjects with their perspectives on the world. Secondly, many of the worst complications, to put it euphemistically, for the rule of law in many countries have nothing to do with the state. The Taliban is not in power. Al-Qaeda it's actually a globalised, non-governmental organisation, aspect of civil society, which we praise so much. It's not a state operative. Last year in the journal, the Hague Journal of the Rule of Law, they had an issue 20 years after the fall of the Berlin Wall, and I edited it. And one of the best, I think, contribution came from a Bulgarian who said that there is a paradox in post-communist societies, that constitutional law seems to be ticking along. I won't talk about that, but it's what most Western observers look at, because the constitutional judgments are long, they're written by professors, they're interesting, they take up interesting subjects. It's just that nobody in these countries pays much attention to them because that's not where life is lived for most people. Politicians pay attention to them. That's important. But the paradox is that with this quite successful constitutional law go dysfunctional courts. And Gaita asks, well, why is that? And he gives two reasons. One is neither of them, and he's talking about courts, remember, he's not talking about ordinary life, he's talking about why are the courts, these preeminently archetypal legal institutions, so lousy. And his explanation has two elements, neither of them to do with the character of the courts. A lawyer would say, oh, well, the judges aren't well trained enough, etc. It's all true, many of them aren't. But his explanation says, look, post-communist states are very rich and very ineffective, very weak. So thugs want what they have, they don't want what they can do. They can't do much, but they have a lot. So if you in Russia can get off Gazprom or some other state enterprise, you can become a billionaire like that. You want to suck the assets from the state rather than have a thriving state. So that's a problem, a big problem in a lot of post-communist countries. But another one, a more general point, is a social point. What are the social preconditions for, in my terms, the rule of law to be effective? He says there you've got to measure the disparity between the average burglar and the average victim. If the average burglar, which is just his metaphor for predator, if the average burglar is poorer than the average victim, then you've got very strong forces in favour of law, legal effectiveness, legal enforcement. If the average burglar is richer than the average victim, then you've got very powerful social forces which are hostile to the rule of law and in a very good position to undermine it. Now that happens to be the case in many parts of the world. The average predator is stronger than the average victim. That's got nothing to do intrinsically with the good or bad features of the legal institutions, but it has a great deal to do with the possible effectiveness of legal institutions in delivering non-arbitrary power. Finally, the goods of the rule of law. Some of you, I can see a couple of people here who look perhaps as old as I am, will remember that there was a controversy between the distinguished British left historian, had been a Marxist for a very long time, E.P. Thompson, about a book. In fact, the controversy was only about 11 pages of a book he had written called Whigs and Hunters. It was a book about the rise in the 18th century England of capital offences for poaching. It was called the Black Acts because these poachers used to black up to poach for gain. And he wrote a book which sought to expose in rather conventional Marxist fashion the class alignments which explained the rise of these laws. But then he has it almost as a conclusion, but an appendix, 11 pages, which says, but this is not to say that the rule of law is a fraud, is a mirage. On the contrary, he said that the rule of law, the imposition of restraints, effective restraints on the possibility of arbitrary exercise of power is, he said, and this for a Marxist, these are of course fighting words, a cultural achievement of universal significance. And this outraged a lot of his erstwhile allies, who became his enemies, and so the controversy. I was on Thompson's side, it's the first time I'd liked him, and I liked him from then on, and that was what the controversy was about. Could somebody of the left say such a nice thing about the rule of law? But there's another issue, which has not been picked up, which seems to me so illuminating in his discussion. When he wants to say that 18th century England was a law-imbued country, and the law was a restraint not only ordinary people, I'm sorry, but even the elites, which it also benefited because it was their law in its substance, but it restrained them. The ideology of legal restraint and the rule of law restrained them. Where did he look? He didn't look at the institutions, he didn't trust the institutions. He said, when somebody harmed by an arbitrary exercise of power, some peasant or somebody working in the fields, they were outraged because they believed that their legal rights, their understanding of what they had entitled to, where this border ended and where it began, this was something in their world rather than in the legal institutions. The institutions may well have contributed to it. But the goods of the rule of law are much... It's not an either-or thing. I'm exaggerating the difference because I want to get this message across. The sources, the dangers and the goods of the rule of law very often come from outside the legal institution. Let me conclude with my fourth question. I do have 5 minutes, so I will go on to the fourth question, which is, who cares? I go to a lot of conferences on the rule of law, and they mix usual suspects. There are judges, there are legislators, there are theorists, there are lawyers of various sorts. And when you go to such a conference, it is a bit bewildering. It's a bit like those films, Chicago gangster films, where somebody bangs on a door, is it Mr. Capone in there? And the answer is, who wants to know? And very often asking about the rule of law is a bit like that. I mean, you've got to find out, where's this coming from? And of course, it's a complex notion. It's a bit like the blind man and the elephant, and also there are many of these conceptual difficulties in the idea of it that I've sort of skated over. But I think there is one who wants to know question, or one distinction, which seems to me crucial in thinking about the rule of law, has rarely been observed, and matters most where the rule of law or its generation matters most. And that is a distinction between people who think about the rule of law in circumstances where they are trying to achieve it against dangers not yet tamed of routine exercise of arbitrary power, and those who speak about the same concept in societies such as ours, with long legal traditions, established legal institutions, professions, organisations, etc. Very often, no distinction. The only distinction that is allowed in a great deal of rhetoric is, of course, it's harder in Afghanistan. I think it's deeper than that. I think that the problems are different. Lon Fuller, who I've mentioned a number of times, talks about lawyers as social architects, which is a good image. He means both in ordinary law, if you give somebody a contract or a corporation, you're in some way structuring their affairs. But he means it also in regard to the building of legal institutions, and there I think that the metaphor can be overstretched. People trying to generate the rule of law in societies where it is absent, weak, been destroyed, etc., are in the positions of social architects, building very often on remarkably inhospitable soil. People catering for the rule of law, or worried about the rule of law, concerned about the rule of law in societies like ours, are in the business of running repairs. Sometimes these are very important affairs. It's not that the dangers we can think of the war on terror cannot be acute. They can be acute. But there's a lot to draw on, not available to societies where the rule of law is in particularly bad shape. And this leads to a sort of two-pronged reflection. On the one hand, in the societies where the rule of law is still a project, not achieved, attention, as is so common in rule of law promotion, to the purity and structure and workings of legal institutions is only a small part of a very larger picture which lawyers are not trained to address, not particularly apt to address, and the things they focus on are not particularly useful in addressing. On the other hand, if you think, what do you need? Sometimes your devotion to the rule of law has to be rather crude. You're still trying to build certain sorts of structures which you should defend with a great deal of zeal. It won't be enough for the reasons I've given, but it's precious. In societies like ours, it's not an accident, and it may not be foolishness, that when people talk about the rule of law, they talk about the law because we live in luxury, in situations of luxury. The social work, the social fundaments of the rule of law in a country like Australia are things we think nothing about, and perhaps we don't need to think much about them, at least in the short term, because they've been dealt with not by us, but we're the lucky, unearned beneficiaries of a whole range of achievements which have allowed the rule of law to be implanted. Then it may be appropriate to think just about the institutions when you're thinking about the rule of law. On the other hand, you shouldn't be timid. You have less reason to be timid. If you remember the reaction to the Mabo case or the reaction of conservatives to the welfare state, or on the other side, the sort of contemptuous reactions of people on the left to the rule of law, both of these, it seems to me, very often those contemptuous reactions and these nervous reactions of conservatives stem from the same misidentification of a problem. If the rule, Friedrich von Hayek is one, if the rule of law is not absolutely clear, covers all bases, is open to any kind of attempt to respond to complex social situations, then the rule of law is on the skids. In our luxury circumstances, it takes a lot to put the rule of law on the skids, a great deal. And so to manufacture to generalise the kind of difficult structural conditions necessary for the rule of law in circumstances where they have been achieved is to exaggerate the problems we typically face in our society in maintaining, securing or extending the rule of law. We might be prepared to take, it might be appropriate to take some risks with the rule of law for other goals or other achievements because in our circumstances they're less risky. To conclude, and that's true, truer words have not been spoken, I will conclude. Often my conclusions are a rather running commentary on the 16 points I have to make, but still, now I will conclude with 2 points. First of all, I've been trying to say that there is an intellectual error that underlies a lot of talk about the rule of law. And I want to say, on the one hand, it may not matter much here, because the rule of law doesn't need you and it doesn't need me in the short term in a country like this. I'm exaggerating the point to make it, but compared to a lot of countries, I think that's a rough truth. But in countries where the rule of law does matter, where it's a goal still unachieved, a misconception of what it might involve, a kind of silo view that law is all about the justice institutions and the courts, etc., that the rule of law is all about those, can be a tragic misconception, or at least an unavailing one. And the general point of all of this is to argue for a version of a phrase that, again, is not mine, of contextual universalism. It seems to me that the goals of the rule of law truly are universal. I don't know anyone anywhere who deserves to be the routine victim of arbitrary exercise of power. But what is required here, there or somewhere else to generate, more accurately, catalyse, if you're lucky, the rule of law is still a mystery to which we have very few answers, and the so-called answers we have proven to be ineffectual in the main, and as Marxists used to say, I don't think that's an accident. Thanks very much.